Yeah.
For Mexico troops, they're having trouble with trying to get video.
Okay.
So right now we're only having audio, but
Okay.
no actual picture.
Okay.
We may for a minute.
Yeah, we'll hang on just for a moment. At this point, we have audio, but we're waiting to get our video set. So as we wait for that, let me go ahead and welcome everyone to tonight's forum for candidates seeking judicial seats in Cole County Circuit Court in the August 4th primary election. I'm Gary Castor, managing editor of the Jefferson City News Tribune, and I'll serve as moderator of tonight's forum. So at this time, I'd like for us to stand and say the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. All right, so I want to take this opportunity first to thank the city for use of the council chambers and for allowing us to hold the forums here, as well as JCTV for taping and airing the forums. Obviously, we've done these for many years. This is a little bit different climate for us. In the chambers today, we have only the candidates and those here who are producing the forum. So we are streaming the forums on newstribune.com. They're also showing on JCTV. And so we appreciate the opportunity to use the space and to engage with the candidates. Tonight, our first forum is going to feature the candidates for Division 5 Associate Circuit Judge. That forum will be followed by forums for Division 2 Circuit Judge, Division 3 Circuit Judge as well. Prior to tonight, the candidates were advised the rules of the forum, which will include opening statements, general questions for the candidates, and closing statements. Candidates will be given 1 minute for an opening statement. As we begin the questions, the candidates will have 2 minutes to respond for each question. Rebecca Martin, News Tribune City Editor, will serve as the timekeeper for tonight for those responses. None of the candidates were given questions before tonight's forum. During the course of the forum, I may ask a candidate a follow-up question in hopes of getting a clearer understanding of his or her stance. A candidate may also be granted time to respond or rebut an answer from a previous question. So now, let me introduce the candidates for tonight's forum for Division 5 Associate Judge. The order by which we're going was determined by lot before we began this forum. So starting off will be Matt Willis, a public defender for Cole and Miller counties, Miller and Montauk counties. Tim Anderson, a former Assistant Attorney General for the state of Missouri. Todd Smith, former Cole County Assistant Prosecuting Attorney, who is currently in law practice at his own firm. And Brian Stumpe, currently Jefferson City Municipal Judge. Previously, he was also Jefferson City Municipal Prosecuting Attorney. The winner of the Republican primary will face uncontested Democratic candidate Scott Evans in the November general election. So at this point, let's get started with our questions, and we'll begin actually with our opening statement. So we'll begin with Matt.
And thank you very much. Thank you for having this forum. It's an honor to be here and an honor to make my case. I was born and raised here in Jefferson City. I was raised by a single mother, and I was raised by my grandparents. They taught me the value of public service. And I stayed here locally for my education, graduating from Jefferson City High School, moving on to Lincoln University, and then to University of Missouri Columbia for my master's degree. And then I went to St. Louis University for law school. And it was an honor to be able to and it was an honor to be able to come back here.
Okay. Is the microphone on?
Oh, can you hear me now?
There we go.
Okay.
All right, so I'm sorry, first of all, let me apologize for that. Matt, let's start over again,
Okay.
all right?
All right. I'm born and raised here in Jefferson City. I was raised by a single mother, and I was raised by my grandparents. My grandfather was a social worker. My mother was a nurse. And they taught me the value of public service. And after graduating from Jefferson City High School, I stayed here locally for my education. I went to Lincoln University and then the University of Missouri-Columbia for my undergraduate degree. And then I went to St. Louis University School of Law for law school. And it was an honor to be able to come back here to Jefferson City to work as a public defender. And I've spent my career in public service as a public defender, and it's not always the easiest job. There are long days, there are difficult days, and it's a 24/7 job. But it's ultimately a rewarding job, and it takes a lot of determination, perseverance to do the job, and I'm ready to take the same passion and determination that I use in my job right now and use it as your Associate Circuit Judge. Thank you.
Thank you. Tim.
Good evening. It's a pleasure to be here as well. I'm Tim Anderson. I chose Jefferson City 35 years ago. I married my wife 33 years ago, and we made this home. We have 3 kids and now 2 granddaughters. I've been with the Attorney General's office for the better part of 30 years, and my experience has been one of depth and breadth, I believe. I've been in federal court and state court, in appellate court and trial court, in criminal case, in civil cases, and I believe I've seen literally hundreds of judges, some very, very fine, some whose political affiliation I didn't know, but were tremendous judges. And I think my experience, my commitment to this community, and the challenges I faced thus far will stand me in good stead.
Thank you. Todd?
Good evening. My name is Todd Smith. It's a treat to be out here with all you good folks. I served as an Assistant Attorney General in the Criminal Division on High Street. I worked as an Assistant Prosecuting Attorney for Cole County. In the midst of that, I also spent some time working at a civil law firm in Columbia, and I now have my own solo practice. When I graduated from law school early, I earned a second advanced law degree. Can you hear me now? How about that?
That's better.
I'm so sorry about that.
That's all right. Let's start over again.
Sure. Again, my name is Todd Smith. It's a treat to be here with all you folks. I was an assistant prosecuting attorney here in Cole County. I've also served as an assistant attorney general in the criminal division on High Street. I spent some time working at a civil litigation law firm in Columbia, and I now have my own solo practice across from the Cole County Courthouse. My legal education was somewhat unusual. I graduated law school early and then continued on my legal education. I earned an advanced postdoctoral degree in constitutional law. I have certificates in constitutional law and civil rights. That education and experience has really informed my life as a lawyer. I'm a constitutional conservative. I believe in law and order, and I believe that those attributes, that advanced education, my time in public service and in private, in doing criminal work and civil, puts me in a very good position to serve the citizens of Cole County as a Division 5 Associate Circuit Judge. Thank you.
Thank you. Brian?
Thank you, Gary. My name is Brian Stumpe. I'm currently the municipal judge here in Jefferson City. Before that, I was the prosecutor here for 4 terms. But I want to talk about my family a little bit. I grew up here. I wrestled at 98 pounds in high school, which you can't believe today for JC. I moved overseas for several years, met my wife on a bus in Hungary, and came back and married her. And we have 8 kids. We've been married for 23 years. My legal experience, I worked in civil law. I've done criminal defense. I've done criminal prosecution. I've done work in front of the AHC, Department of Revenue. I've done civil litigation as well. I've done soup to nuts. But most importantly, I've had the experience as the prosecutor and as the judge in this court. And I am here to be able to start on day one, hit the ground running with the experience required to serve as the associate judge in the 5th Division. I went to law school, a little school called Notre Dame in Indiana, where I studied under some of the greatest minds in the legal field today. I'm here today to ask you to vote for me on August 4th, Republican primary. Thank you.
All right. Thank you. All right. So now that we got our microphone issues out of the way, I apologize for that. So we'll get started with our first question. So we'll start with Tim. In what ways are you reaching out to members of the public to determine what they value in a judge? And what issues have members of the public told you are important to them, and how would you act on those as a judge?
Been reaching out to many people, and frankly been doing so over the last couple of years, and I have enjoyed that. I've enjoyed the heck out of it. Even though I lost a couple of elections, it's been a tremendous experience to really gauge the pulse of people who typically don't see the courts, and that was different for me and important for me. The second part of your question, Gary, I'm sorry, I missed.
No, that's good. What issues have members of the public told you are important to them, and how would you act on those issues as a judge?
The biggest issue I've heard has been the release of people on bond. There's been quite a bit of wrestling back and forth with that issue, and it's important, I think, that number one, our goal is to protect the community, and then following that, then there are opportunities to work to better the possibilities for the criminal defendant. There are different alternatives to incarceration. There are restorative justice options that I've seen. I had an opportunity also as the attorney with the Attorney General's office to be a part of a drug court, and it was illuminating for me. And then coupled with that, I also would do some work with Prison Fellowship, where we'd go behind the bars of the old MSP and have a Bible study. So I think many of these issues, how best to address, how best to work with typically young people and typically young men who've made a mistake, what to do with them, at the same time protect the community.
Okay. Todd, same question.
Sure. I declared my candidacy last fall and started going to a lot of events, and that's my primary way to communicate with the electorate is, go out to the special events. For example, in Lent, went to a lot of fish fries, a lot of pancake breakfast, talked to a lot of folks, and I would echo Mr. Anderson. The primary consideration of folks in the community is, it seems like we have a lot of folks that are out on bond. We have, read the newspaper, someone's been arrested for a serious crime, and they are concerned about that, and I think I am, and I think the folks who work in law enforcement are as well. So that is a major concern. And then the second one that has come up has been, what about COVID? Those fish fries stopped happening, and all of us stopped having events to go to. And the courthouse became a much quieter place. It has cases for juvenile cases, in custody criminal cases, but civil litigation, at least in a courthouse sense, almost came to a halt. And folks are curious about that. I have a civil dispute that I'm in, and I'm curious about when I might get my day in court. And that process has been frustrating for attorneys and for clients both. So those are the two main things. Public safety, what is our relationship with violent and repeat offenders in Cole County, and when are we going to start to have our civil litigation back in order?
Okay. Brian?
Thank you. I've had a different experience. The biggest question and concern I have for people is fairness. How do they know when they come to court they're going to be treated fairly by the judge and fairly by the prosecutor, things like that. And I think the way to address that is one, to understand that Lady Justice is blunt, right? We are all going to be umpires as judges. It's our job to call balls and strikes. You have a set of facts and you have the law. And if you apply the facts as they stand to the law as it stands, before you go into court, you should know the outcome. There should be no tricks, no punches pulled, nothing like that. It's our job to say the law says this. We won't change the law, we won't rewrite the law, but we will simply apply the facts to the law. And overarching, that's been the biggest concern I've heard from people as I've been out talking with them. As Todd said, we got cut short on the fish fries, which was very bad for me. But just had a great time talking to people regardless of that. And really overarching is how do you be fair to people? And I think we've shown that, at least I have, I think, in the past 10 years at the city court, by treating people appropriately, by treating them very fairly, by trying to meet them where they are, and not just saying, here's the outcome, but why are you there in the first place? To see the whole situation, the entire picture, so you can apply the law to that specific person and those specific facts to the law to find the proper outcome. It's not our job just to put people in jail, right? There are some people that need to go to jail, and we've got to be willing to do that. We're willing to pull the trigger and say, you know what, you got to spend some time away because you're a threat and danger to society. But there's also the young kids out there that are kicked out of their house, that have a drug problem, that have quit school. And how can we take that child there and take them from being in a destructive path to being a productive member of society? We've developed programs to try and address those issues as well.
Thank you. Matt?
And when I started this campaign, I think actually the week that I had planned to start door-to-door is around the time that COVID hit the United States. And door-to-door just was not going to happen. So I've had to do a lot of things differently this election. I have had to reach out to people via Facebook, via digital. I've had to speak to people virtually, which I did not expect to do when this campaign began. And their concern throughout this entire campaign has been, what do we do with the coronavirus? What do we do with COVID? And also, what do we do in the court system once COVID lifts? Because there's going to be a backlog of cases that are going to come before us once coronavirus finally leaves the states. We're able to return to a sense of normalcy. So how do we do that? So when do I have my day in court has been a question from a lot of people. And also, what do we do going forward has been a question.
Okay, thank you. All right, our next question will start with Todd. What do you perceive as the greatest obstacles to justice, if any?
In the Associate Circuit Division, we're going to have a great many cases that are pro se, and that means folks without lawyers. And our legal system has gotten to the point where it's quite complicated. It's a dangerous forest for amateurs, and the reality is folks don't have really good access to attorneys, and that inability to get legal counsel causes systemic problems. It bears upon the efficiency of our criminal justice system. It bears upon the fairness. And so if there were a particular part that is unfortunate, is that every single person in court for every single case can't get themselves a good lawyer. Now, of course, you have a constitutional right to in a criminal case to counsel, but, in your landlord-tenant disputes, in your family law matters, there are folks every day in the Cole County Courthouse that are not lawyers, perhaps not even high school graduates, trying to navigate that process. And those folks, we try to give them a fair shake, and they do get a fair shake, but it is troubling to imagine the rates of a person, particularly the other side is represented. And so the access to legal counsel, and that's a resource problem. It's no one's fault. But in an ideal world, we would have more of that. And it strikes me that more lawyers not only make a fairer system, but I do believe, as I said, it creates a more efficient courthouse. It makes the machine be more well-oiled if you have attorneys there in more cases. And so it would be my opinion that it is a shame, not so much as a defect, it's no one's fault, but it's a shame that we don't have greater access to legal counsel in various cases.
All right. Brian, same question.
Gary, would you please repeat the question to me?
Absolutely. What do you perceive as the greatest obstacles to justice, if any?
I think the greatest obstacle to justice that we have right now is that we live in a society of win at all costs, right? So is the prosecutor there for wins and losses, or is the prosecutor there for justice? Is the judge there just to put you away forever, or is the judge there for justice? Is there an axe to grind? And so I think that the thing is that we've got to make sure that we understand that each case is an individual person. It's an individual situation here. And we've got to take that into consideration. Because all of a sudden when the defense attorney just goes along with the prosecutor and the judge along with the prosecutor, we got a problem. When I was in Indiana, I remember a white guy stole a car stereo, all right? And a Latino guy took 2 Twinkies from the store. And the white guy got a diversion program, probation. And the Latino gentleman, he went to jail. And the same court, I saw a white guy with methamphetamine get diversion, and a black man with about 4 grams of marijuana go to jail. And when you're concerned about wins and losses and how you're going to punish people only, we've got a problem. Hardened criminals, they need a certain kind of punishment, right? But in the associate division, we're dealing with misdemeanor cases, not with felonies. Violent crimes don't come there. And we've got to make sure that we can address the issues to say, hey, how do we keep you from becoming the repeat offender? Are we just there to throw you in the jail and throw away the key and lock you up forever? Or are we there to say, hey, how do we fix the society? How do we fix the system, the broken system, to make sure you don't do it again? If we're just there to punish you, if we're just there to get wins and losses, we don't really care about society as a whole. When I was at the municipal court as the prosecutor, we started a DWI program for first-time offenders. The average recidivism or repeat offender rate in America is 20%. People went through that program, it was 5% over 7 years. You got to be willing to take chances and fix those things.
Okay, thank you. Matt, same question.
I think I would echo what Judge Draper said this year at the State of the Judiciary address, which is that the system does not work without a fully funded, fully staffed public defender system. And the lack of funding for the public defender system, the serious underfunded nature that we have, the understaffed nature that we have, that we're dealing with so many cases, such an overloaded caseload, has been an obstacle to justice for a lot of people. And it's something that public defenders around the state have been bringing to light. The Republican legislature that we have right now has, these last few years, really been looking into it and doing what they could to increase our funding as best that they could. And so that's been helpful, but we still have a long way to go, I think.
All right. Tim?
A couple of things come to my mind. First is character. I have an example. Tried a murder case with a good friend of mine. The defendant was convicted. After the case, my good friend, in this hour, he told me, realized that there was something wrong with the prior offender status that we had pled out. And so he, on his own, brought that up to the court. It was corrected. Turned out it worked out just fine. But character is something in short supply really across our country. And I think a lot of that, and it's not just lawyers, it's those who go into the courtroom and swore to tell the truth. It's important that we understand our history, our foundation on law, and the importance on justice and on truth. And too often we have people come in and they'll want to shade the justice or shade the truth, and that's number one. The second part is communication. I think in so many of our cases, whether a public defender, a defense attorney, prosecutors, when we interact with people, it's important that we understand this is not a case, just a case. It's a case involving real humans. In many of the cases I handled, I would work directly with the victims. And one in particular still tugs at my heart, a little 5-year-old girl who was sexually abused by her biological father. And I developed a good working relationship with the little girl and her mom and her grandparents. And I have not had a better feeling than when that conviction was announced. And at the same time, my heart broke because the little girl came up and you could tell she wanted to give me a hug, but because of what had happened, she didn't know what a good hug was and a bad hug, and so she pulled back. So there's opportunities.
Okay, thank you. All right, Brian, next question, we'll start with you. Will you commit to monitoring sentencing data so racial inequities can be detected and remedied? You mentioned what is the solution for achieving racial equality?
Are you asking me, is there inequality? Will I commit to monitoring that?
Yes.
Or are you asking me for a solution for the inequality we see in the United States today?
Both.
And I have 2 minutes? Yeah, I'll commit to the monitoring of that issue. I don't have a problem with that at all. In fact, we just sent some data to Kansas City for a program to monitor different disparity issues that exist. The solution, well, that's a heavy question. I mean, the solution, I think, starts not necessarily in the court system, but in the education system. So often you see those people that fall behind or being left behind, they don't have the same education that other people do. They don't have the same opportunities that other people do. And that lack of education then creates not just the racial disparity, but an economic disparity as well. And so it's magnified at that point. And so when we're creating two classes of people, the haves and the have-nots, the educated and the uneducated, when you have schools that get disparate funding, and that you have those that are left behind because of just where they happen to be geographically, and the people that live in that area are financially hindered, you create a system that's bound and determined to fail. So until we get a system that at all aspects creates people equally, we are going to foster a system that has inequalities within it inherently. So is it how the court does it? I think it's much bigger than just the court doing it. The court, Lady Justice is blind for a reason, right? And so the judges have to treat people absolutely equal no matter where they come from as far as their racial background. We can't do anything but that. But the solution to the problem is so much bigger than just a simple court stepping in and saying, I want to do this or do that. It's going to be a holistic approach of society that that people have that equal footing, that equal opportunity and chance. And you just don't see that right now. You see failing schools in impoverished areas much more likely than failing schools in wealthy areas. And until we have the education system where people are there equally and given that same chance, we will always create a system of haves and have-nots.
Okay, thank you. Matt?
Yeah, as to the data question, I think that is necessary, and I would definitely commit to a system that looks at racial inequity within the justice system and sentencing issues. As to the bigger question of solutions, I would echo Mr. Stumpe. It's tough to come up with solutions that one judge could do. I know one of the benefits is that Missouri Bar, as part of the continuing legal education, has added bias components to our legal education, so that we have to look at ways which we may be biased, or that the court system may be biased towards some groups of people. And that is certainly a potential solution, but it's not the end of the story. There still is a lot of work that the legislature would need to do, that society would need to do, not just in the state of Missouri, but nationwide to an extent. But certainly to what extent I would be able to do something as an associate circuit judge, I would commit to that, certainly.
Okay. Tim?
About 20 years ago, when I was with the Attorney General's office, one of the tasks I had was to work with a group and develop what they called a traffic stop form. And the purpose of that was there were many complaints about driving while black. The complaint was that our black citizens were being pulled over more frequently and they were being searched more frequently. So I got really in on the ground floor with that in devising a form. And it's a difficult thing because the bottom line is we don't know the heart of a man. We expect our law enforcement officers to administer the law fairly and impartially, and in my experience, a great percentage of them do. Periodically, different biases come into play. I'm all in favor of any statistics we can get that can help us to determine what is a root cause. Now, the question with all that is, again, when you can't see the intent of a man, is what are the circumstances leading to the stop? And it's really interesting to talk to people in communities who say, we want the police in our communities. And the reason we do is because our communities have been taken over by violence. And so the very communities sometimes that many of our stops are in, the police are there to help out the people. They've been called to that community. So it's important. The second part is teaching our kids. I was privileged to teach at Lincoln University and also at Lighthouse, and I enjoyed that greatly. And what I tell each of my kids at Lincoln, when we talked, I had a class on police in the community, and I said, what are your biases? And we talked about them. But it's important that they understand what the police are doing, and what the law is, and at the same time say with the traffic stop that Just obey what the officer is asking you to do. And then if there's a problem, you can get to it later.
Okay. Todd?
You know, if I think the judicial process can benefit from study and academic research. If folks want to have statistics about what happens in my courtroom, that's fine. If they get some interesting findings, I think that's useful information. Certainly would use it. But the plain fact is we have a Constitution, we have a process. I have faith in that process in our Constitution. And what color your skin is doesn't matter at all. What did you do? What are the facts surrounding your conduct? What does the law say about that? Did you do it or did you not? And what are the various factors that compel us to punish you, and if that punishment is going to be incarceration or not. At no point in that equation do you get points for being white or lose points for being black or whatever else. I feel very confident what a judge in our division can do is every day make sure that the due process rights of every single defendant are being scrupulously obeyed and protected, make sure that their constitutional rights are not being trampled. If you see a constitutional violation that merits dismissal of the case, that's what you do. It's that simple. And I believe that what I can do, to the extent that statistics demonstrate a disparity, stick to the law, stick to the Constitution. It doesn't matter what that person looks like. It matters what they did and what we need to do about it. And I have a great faith in that process, and I think that's what the community wants their judge to do. Follow that law, keep that machine moving. Doesn't matter what they look like. And I really do have a great faith in that. And if the statistics suggest that there's a problem, adjustments are great and improvements are important. But I think that you can be devoted to a very significant degree to this process. The process is more important than your passions or your own discrepancies or discrimination. It's the process, focus on that, and the results, I think, will be fair. And I'll be happy to stand behind the results that come from that process.
Okay, thank you. Let's see, Matt, we start with you for the next one. Gun violence is a concern for many in mid-Missouri. How would you approach cases involving the use of weapons in a crime? What role does a judge have in stemming gun violence in society?
So I think one role of a judge is to be the voice of the community. A judge has to not just be the voice, but sort of reflect the values of that community. And yeah, gun violence is a huge issue here in Cole County. I think with cases like gun violence, you do have to take a more firm stance than you would with, say, a lowercase felony or some first-time offenders. So you do have to look specifically at violent crimes a little bit differently than you would any other case.
All right. Tim.
The Missouri legislature many years ago gave prosecutors and our courts the tool to attack gun violence, and that's an offense called armed criminal action. And that's gone all the way up to the U.S. Supreme Court and been ruled to be constitutional. It's not double jeopardy. So a person who commits an offense by, with, or through the use, assistance, or aid of a gun or other deadly weapon, they're facing not only the original charge, say burglary, robbery, murder, assault, but they're also facing an additional charge of armed criminal action. And one of the beauties of that is it's at least 3 years. If they're convicted and found guilty of both, they're sentenced to at least 3 years up to life. So I think we have that tool. I think judges, I think members of our society, we have to discourage the use of guns in an illegal fashion. Now we've got a lot of people who use guns and use them wisely. I grew up and people would drive to high school and have a gun rack in the back of their pickup truck, and that was great. That was fine. But now we're in an era where many times people are purchasing those guns with wrong intent. So we have the weapons, we have the tools, we just need to use them.
Okay. Todd?
I would echo the idea of using armed criminal action. In particular, a judge is supposed to follow the law. SB 600 was signed by Governor Parsons a few weeks ago. It becomes effective August 28th. It is an amendment to the Armed Criminal Action Statute that adds even more repercussions for using a weapon in the commission of a crime. Our legislature has seen fit to enhance the penalties and enhance the scope of liability, the number of circumstances that would justify this charge. And our populations want that. It's clearly what the citizens want. And as an associate circuit judge, that's fine. If this is what the political process has given us, a stronger, more effective ACA, all the better. And I'm happy to follow that new law and use it. My other reaction is one of the major functions, every single criminal case starts in the Associate Circuit Division, including the felony cases. The preliminary hearing occurs there. There are a few that go to a grand jury, but every case on paper starts in our division, and one of the major functions of our division is to set bond. And we have basically two criteria. Is this person a flight risk, and is this person a threat to the community? Obviously, if you have a case where someone used a gun and there was a shooting, that is going to prey heavily in the calculation to determine what that bond should be. The law directs me to look at a threat to the community. This person has engaged in a violent act. So to the extent you have a criminal case involving a weapon, we do have a special statute. It's just gotten a lot stronger. I'm going to use it, and I think that our law directs us to consider safety in determining bond.
All right. Brian?
In October of 2009, I was at my office with a group of guys, and I walked outside, and the guy says, "Put your phone down." And I looked at him, I waved to him, I didn't know who he was, and he then put a gun to my head and said, "I said put your phone down." When I put my phone down, he then instructed me and my friends to go inside my office. He put us all face down. He gave one guy a bag, told us to take off all of our jewelry, our wedding rings and watches, take out our wallets, our phones, and lay them down in front of us, and told the guy to pick them up. He then walked behind me, grabbed my friend Justin Cedars by the back of his coat, picked him up by his coat, put the gun into his stomach, and pulled the trigger. And he shot him over and over and over and over again, right next to me. And that really tempered my view on gun violence, right? As my friend is shot 4 times there next to me. JCPD was there in minutes. They arrested the perpetrator. He got 75 years. It was his 4th armed robbery situation. When it comes to gun violence, and you come in front of me as a judge, I have no tolerance for that. I have no tolerance for violent criminals. The bond will be set high for those situations because it's clearly a threat to society. It has a massive impact on people's lives. And people will not want to come see me if they're involved in gun violence as a judge, because I'll be very harsh and very tough on those types of cases. I speak a lot of how do we fix people, and how do we help people out, and how do we help change their lives. And those are nonviolent offenders. But the violent offenders, they need to be treated as violent offenders. And so with the gun violence, I will then treat them as very harshly in my court.
Okay, thank you. So during the course of the forum, several of you have mentioned one of the concerns the public has expressed to you is the use of bonds when bonds have been given to those in the system. So how would you determine when a bond should be given and when it should not? We'll start with Tim.
I look at the bit of facts that I am given about the individual. It is important, I think, that we understand so many of the criminals, the people that commit an offense, thank you. So many of the people that commit an offense have been through the system before. And it's important that we recognize that. The Attorney General at one point made me the head of the meth strike force. And one of the cases we had, we went down to the boot heel, and there was a fella who had been arrested and charged 6 times and was released on bond each and every time. And we went down and were able to change that. But it begins with the prosecutor, it then goes on to the judge with the responsibility to protect people. At the same time, I had a case against a fellow, first name LaRue, and I was in front of a judge. He said, "Mr. Anderson, what is your recommendation for punishment?" And I said, "Judge, he's selling crack cocaine in a children's park. My recommendation is 25 years. And he was appalled. He said, "That's no offer." He said, LaRue's a good guy. And I said, Judge, LaRue has 11 prior felony convictions. And he went on to say, well, who's going to testify? And I told him who. I said, we've got one guy also who's in prison who will testify. And he said, but if that guy testifies, it might not work out well for him if LaRue gets convicted. I said, but Judge, LaRue's a good guy. So we agreed to differ. LaRue was convicted. The judge sentenced him to 25 years in prison. So it's so important to look at, and that's where you use your discretion and your experience. It's so important to have that and go forward with that.
All right. Todd?
So let's understand the process. Someone's been arrested for a crime. They go to jail. In 48 hours, the Associate Division needs to set a bond. You have a very preliminary piece of information. The vast majority of people, the default position is you're going home. People don't, the first-time offenders, folks that are nonviolent crimes, the bulk of crimes that are committed are things where we're not even talking about setting any kind of bond. We're prepared to have you on an ROR bond or cognizance bond. We trust you to come back. But the Missouri Supreme Court, in an effort to address jail overpopulation, a significant problem for our entire state, we're very well situated here in Cole County with the size of our jail, they direct us to ask ourselves two questions. Is this person a flight risk? Is this person a threat to public safety? So let's presume we're not talking about nonviolent offenders. Okay, this person's violent. Well, what exactly did they do? There's a difference between getting in an argument at a party and hitting someone from committing an armed robbery for pecuniary gain. That kind of violence makes our calculation easier. Is this person from here? Goes to work here, goes to school here, grew up here, has never not lived here. That person's going to probably come to court. This individual has never been here before, showed up and committed a major drug felony. I'm worried they're going to skip town the moment they can. And then we have the career criminal problem. So this particular individual is not a serious violent crime. We're not talking about a shootout, but this is the 10th or 20th time that they've been arrested for a major problem. We start to worry. They're not going to go out and shoot someone, but are they going to go out and continue to harm our community, be it a property crime or a drug crime? That is the process we're required to do. That's what I will do. And again, the default is, we don't need to clog up our jail, but we do have folks that's the appropriate response early in the case. They're still technically innocent. And that's why it's such a limited focus. Are you going to come back to court when we need you to? And if we let you out, are you going to go out and break more laws and hurt people? And thankfully, there are not very many people that you need to engage in that process. But when the process does, those are the criteria.
Okay. Thank you. Brian?
Thank you. So the flight risk and the threat to society are very, very important things. And I think the first thing you go to are those two issues to determine, A, should a bond be set? B, how big or small should that bond be based upon those situations? But another important factor to look at is their history, right? Are they on bond right now, and do they violate their bond? And that plays into your decision as well. Is it their first time, their second time, their fifth time, their 15th time? And all of those things also come into that decision-making process. The first-time person on a nonviolent issue is not a very hard decision at that point. The first-time person on a violent issue is not very hard at that point either. But when you have the person that it's not a purely violent, but it's also cumbersome and troublesome issue, and it's their fourth time, and they violate while they're out on bond, well, obviously they did not take the consideration of the bond to heart, right? They're out on bond at this point, and one of their bond conditions is no more or no further law violations. What they did is they took advantage of that bond that they have right now, and they violated, said, I don't care about that bond. So it shows that the bond that was previously set is not sufficient for them, at which time you need to then change that bond, ratchet that bond up, or potentially have a no bond to protect society from those people. But the easy ones are the flight risks. The easy ones are the danger to society. But the harder ones are you've got to dig into the history of the person. What were they doing at the time? What was their background? Are they out on bond at that time? Is this a repeat over and over offense? I had a guy in city court recently with 12 arrests and 12 days for trespassing. At the time, it was under the COVID. It's a catch and release thing. Well, he's going to get out and do the same thing over and over, but it's cumbersome. It's very hard on the business owners where he's trespassing, where he's harassing their customers. At that point, though it's a low-level issue, a bond must be set in order to keep them from going out and doing those same things again. Thank you, Gary.
Thank you. Matt?
And I just want to give a little bit of context to the bail rules, because as others have mentioned, the Supreme Court did 2 years of study looking at the jail overcrowding issue, and what they found is that some judges, thankfully not here, but some other rural judges really were not following the law. People were being held on six-figure bonds for petty theft. One case, it was a $100,000 bond for stealing a can of gasoline. That is not the state of the law. It has never been the law when it comes to bail. Jail has always, in Missouri, been for people who scare us, for dangerous people, or for people who just cannot be counted on to show up for court, flight risks. And so what the Supreme Court did is they set out a list of criteria that judges have to follow. And so if you are going to keep someone in jail, if you believe that person is dangerous or cannot show up to court, you have to set out in specifics why you believe so. And if you believe that person is dangerous, then that person can be held in jail without bond until their case is ultimately disposed, whenever that may be. One other thing I would point out is that in Cole County, I have not seen, other attorneys may have seen it, but I have not seen people get released just out just on their own recognizance. We have a really good pretrial release program in Cole County, and you have to engage with pretrial release if you are given the benefit of being out of jail. You have to show up to meetings with our pretrial release folks, who are pretty stern, pretty stern with people. And if you miss any of their appointments, they bring you back to jail. If you test positive for drugs, they bring you back to jail. A warrant can be issued. So there are a lot of things here in Cole County that can, help us decide when to release people
Okay.
or hold them back. I see my time is up.
Thank you. All right, so we'll begin with our closing statements. You'll have a minute to share with listeners what you would like to say. So we'll start with Todd.
I think I want the folks of Cole County to know that people label themselves constitutional conservatives all the time. I really am. It's almost like a faith with me. I've been studying the Constitution, thinking about our laws for my entire adult life. And I have the second law degree. I've done a lot of research. I've been engaged at every level of academics in pursuing a greater understanding of this law. I'm passionate about it, I believe in it, and I'm prepared to give this county the benefit of that education experience and in a very meaningful, real-world way. This is not a lofty academic discussion. This is in the front trenches of our legal system, dealing with daily crimes, dealing with the legal disputes that happen to normal people every day in and out. And I'm prepared to use that education to do what seems difficult, to be fair and just while being efficient. And I believe that I have the work ethic and the tools to simultaneously keep this machine well-oiled and moving and deal with the backlog and get people in and out and get them the resolution they need, and to do so fairly and constitutionally. Thank you.
Thank you. Brian?
Lady Justice is blind, all right? But she carries some scales. And I want to ask the voters to think about those scales right now. And the scales are a balanced scale. And I'd like you to take my education and put it in that scale and balance that against everyone else's education. Went to Notre Dame, studied under great professors, studied under Amy Comey Barrett, Tex Dutil, who prosecuted the racial issues in the South. I want you to lay my experience on that scale and balancing everyone else's experience. I've done civil law. I've done administrative law. I've done criminal defense. I've done prosecution. I've been a judge. I'm the only candidate with judicial experience that can start on day one, hit the ground running in this situation. And I think when you take Lady Justice and bring her scales out, and you balance Brian Stumpe versus all my opponents, you'll see that the scales tip in my favor. I'm Brian Stumpe. I want to ask for your vote on August 4th for the Republican Associate Division 5.
Thank you. Matt?
Being an associate circuit judge is not a 9-to-5 gig. It's a 24/7 job. And where I work right now as a public defender, it is a 24/7 job. Just last week, I was in court until about 7 p.m., and that was on a pretty typical law day for my practice. And there have been days when I work for my clients until I cannot work anymore, usually sometimes around 3 a.m., sometimes 4 a.m. That's my job. That's what I do. Because the cases, the clients I represent, the cases matter to them. It is the most important case really of their entire life. And it should be the most important case in my life as well as their attorney. It should be the most important case for their judge. And as Associate Circuit Judge, every single case in front of me will be the most important case on my docket. And that's why I'm asking for your vote August 4th. Thank you very much.
Thank you. Tim?
My privilege to be up here with three bright and articulate other lawyers, some of whom, if not all, I share a very important faith with. I'd say a couple of
Turn your microphone.
I'm sorry.
It's all good.
My privilege again to be up here with three bright, articulate lawyers, some of whom I share a faith with, which is important, I believe, because I think if we approach this system as everyone is created in the image of God, there's nobody who's lesser. We all make mistakes. Some rise to a higher level, but we're also told that the standard we're judged by is not actually what we commit, but the intent that we have in our hearts, and so that's humbling. I believe strongly in Ronald Reagan's 11th commandment, and that is, don't speak ill of another Republican, and it's not my character to do so in any event. But the only thing I would say is, if you like your municipal judge, you can keep your municipal judge here in Jefferson City, and I throw that reminder out to the citizens. Brian has done a very good job. As I indicated, I've been a lawyer for 35 years, and I think my experience and my commitment to the community and then my faith set me apart and would provide a good foundation to be a next judge. Thank you.
All right. Gentlemen, I thank you for appearing tonight for this forum, and I would echo your encouragement to voters to get out and vote, and they have 4 very good candidates in front of them on the Republican ballot, and then we'll face a very good candidate for the Democratic ballot as well. So again, thank you. We're going to take a short break.
Thank you.
Return in about 5 minutes for the Division II Circuit Court judges.
Thank you very much.
By thanking you for having this forum. I think it's very important for the people to get as much information as they can, and it's only through work of good organizations like yours that happens. I will be known as Daniel Green on the ballot. My friends call me Dan, so please feel free to call me Dan for the rest of the evening. I am currently the Cole County Division II Circuit Judge. I've held that position for 10 years. It's a little off on the years because when I was first elected, I took the balance of Judge Callahan's term, so I'm in my second term, but I've only been there 10 years. I am the only candidate with the real experience necessary to ensure that justice is achieved here in Cole County. I am a lifelong conservative Republican, and although no judge tries a case based on somebody's politics, I do believe that a judge should reflect the values of the community in which they live. With regards to that, I have lived in Cole County for 30 years. I raised 4 children here. I have 4 grandchildren here. I do think that being a conservative, I do reflect the values of our community. Thank you.
Thank you. David?
Thank you, Mr. Casper. Again, my name is David Bandre. My wife Ginger and I reside in Wardsville. My son resides in Fulton. He's 22. I've had a law practice in Jefferson City for 25 years. I work as a trial lawyer. I work for cities. I represent about 10 different cities here within central Missouri.
Turn your mic on.
Claims to be on. I'm going to start again. My name's Dave Bandre. My wife Ginger and I live in Wardsville. My son Connor lives in Fulton, where he's a soccer coach for William Woods University. I've been a trial attorney here in Jefferson City for 25 years. Since 2001, I've had my own firm, Bandre, Hunt & Snyder, in downtown Jefferson City. And in that time, I've worked in the courts. I've worked in courts in 55 different counties in the state of Missouri. I've practiced before all the courts of appeals, the Missouri Supreme Court, and the United States Supreme Court. I put my courtroom experience up against anyone, whether it's as a judge or as a lawyer. My time in the courtroom has taught me what the law is and has taught me how a courtroom should be run. Thank you.
All right. So we'll start with our first question, David, with you. In a News Tribune story, you mentioned you believe the court, quote, needs to be more available and open. From your perspective, what issues exist now, and what would you do to address them?
I think the biggest issue that's out there is when the courthouse is open, I believe that judges need to be available in the courthouse. There's been a number of times that myself and other members of my firm have needed a judge, have wanted to get a matter ruled on in an exigent situation. That happens. I believe that while the courthouse doors are open, judges need to be there and need to be present. If a docket starts at 9 o'clock and there's lawyers and clients backed up there, the judges need to be available and need to be in the courtroom so that those lawyers are not wasting their clients' money and not wasting time associated with that case. An efficient system, particularly with COVID backing up the court system and leaving a lot of cases needing to be tried, is extremely important. There's not going to be enough hours in the day to get those cases in. And so by availability, I want the courthouse to be there and open, funded by taxpayer dollars, and ready for people to use as often and as frequently as they can.
Okay. Dan, do you believe issues exist with the availability and access to the courts? Why or why not?
Absolutely not. If Mr. Bandre thinks that this is a office-type job, 40 hours a week, then he probably should stay being an attorney. I'm available 24/7. I've received the endorsement of the Jefferson City Fraternal Order of Police, Jefferson City Police Officers Association, primarily because of my availability. Oftentimes my phone rings 1, 2, 3, 4 times a night after midnight. And the police have endorsed me because they know that I'm the judge that is always available. Any insinuation that the courthouse is not open, I'm also confused as to why an attorney would feel like they had a right to come speak to a judge without the other party being present. That's known as an ex parte communication and is illegal. So I think that that is just a red herring at best and a mistruth.
If I could respond to that.
Sure.
Any implication that that would be an ex parte communication is absolutely ridiculous and is nothing but posturing. There are numerous occasions where prosecutors and private counsel, or 2 attorneys involved in the same case, have an issue that needs to be taken up in front of a judge. It happens on a daily basis. The system works better when lawyers have the ability to meet with a judge. It's that simple.
All right. Next question. Dan, we'll start with you. In a News Tribune story, you mentioned members of the public have told you they are first and foremost interested in public safety. What have they shared with you, and what can you as a judge do to address those concerns?
Well, I do think that we are fortunate to live in a community that is by and large a safe community, and I feel that that community is safe because of our law enforcement professionals. I think it's also safe because our judges do reflect the values of the community. And I think when people turn on their TVs and they see rioting and looting and carnage in other areas, they're worried that that may come to our town. And so I think a judge, first and foremost, needs to make sure that everybody is treated in a fair and impartial manner. But if a jury or a judge has found somebody guilty, then the sentencing needs to reflect the values of the community.
Okay. David, do you believe a judge has a role in improving public safety? If not, why not? And if so, what would it look like?
I certainly think a judge has a role in improving public safety, first and foremost to address those individuals who are on the street creating problems and, frankly, remedying that situation on a case-by-case basis, whether that's incarceration, whether that's education, whether that is diversionary programs to teach better ways. That all lends to public safety. From the standpoint of, as Judge Green mentioned, people in the streets and doing those things, I think the courts can assist in that as well. One of the reasons that we have protests out in public is nationwide a lack of confidence in the court system and a lack of confidence that people are going to get their fair shake. Because of that, they take to alternative methods to air their grievances. If they felt that a fair shake was being given in the courthouse, I think there would be less opportunity and less of a belief that those protests have to happen. That's not going to start with one court. That's not going to start with one judge. That's a nationwide issue. But ultimately, we can help public safety by increasing the confidence in the courts.
Okay. Next question regards operation of the courts. David, you said you've noticed social media posts in which people say they don't like the way things are working in the courts. What would you do to improve the function of the courts if you were a judge?
Well, let's start with the fact that there are serious financial problems with the court system. That's not the fault of anyone in this room, but proper funding would assist. We're going to have some issues when that fifth division comes in, just as far as where warm bodies are going to go. Functionality of the courthouse from that standpoint needs to be addressed. There's some very smart folks over at the courthouse who are working on that. Any way that we could assist and that the public could assist in trying to get more funding for the courts here would benefit who's ever sitting in this seat and in any of the other judicial roles. Realistically, beyond that, I think, again, having expanded hours throughout the normal workday for various different dockets, perhaps having those on more days throughout the week, reserving trial dates for certain dates of the week so that we can fit more dockets in and have the dockets be shorter, more attention be paid to each case. I believe that's going to increase the functionality of that court.
Okay. Dan, how would you assess the functionality of the courts at this time, and what would you like to see changed or improved if you're reelected?
I don't think that there's any problem with the functionality of the courts. Here in Cole County, we do have some physical plant issues, like Dave mentioned, that'll need to be addressed since we're adding on a fifth judge. But I have not heard anybody say anything about how they thought that the courthouse wasn't working efficiently.
Okay. Next, let's talk a little bit about campaign finance. So, Dan, as a judge, how can you remain impartial while accepting campaign donations from individuals or groups?
The fact that somebody has paid me money or contributed in my campaign is only an indication that they think I'm a fair and impartial man. And they know that they will receive no favoritism, and in fact, no one has received any favoritism. We run as a partisan judges in contested races in outstate Missouri, and that's the way I want it. But I will tell you that with regards to my race, I would say 80% of what I have raised this campaign cycle has been self-contributed by myself.
Okay. David, same question. As a judge, how can you remain impartial while accepting campaign donations from individuals and groups?
Well, I think it starts with the initial interaction with those individuals who have contributed. Historically, those are friends and people that you know, and you let them know, hey, this doesn't impact business. I'll work hard for you, but you're not going to get any favors. People need to know that in advance. I think it's very helpful. While it's frustrating to fill out the forms, it is very helpful that we have to publicize who gives money and who we receive money from, and also to whom it's paid. I think that gives some level of clarity to the public so that they can look out and know who that is. It is particularly problematic with lawyers and their gifts to these judicial races. I think it's sometimes there's a lot of misperception from the public about that, but that's the world in which we live, and so long as it's done within the rules, that's about all you can do. From a perception standpoint, you just have to work every day in court, and if somebody has a concern about it, you recuse yourself from that case and you move on to the next.
Okay. David, the next question will start with you. The winner of the Republican primary election for this position will not face a Democratic opponent in November. Assumably, if you win the seat in August, you've won it in November. As judges are elected to be impartial, what does it mean to you to run for this position as a Republican?
Well, I've been a Republican since the Reagan administration. In high school, I went and watched Reagan land at KCI and went up there to meet him. Campaigned on behalf of the elder Bush in my younger years. The platforms of the parties have changed somewhat through then, but that's how I associate myself. That's how my parents associated themselves. I think it would be disingenuous to pick another party because they're getting press right now to say, you know, we want this change. I am not 100% convinced that judges should run on a platform of Republican or Democrat, because it should not matter what political bend you have. Your job is to read the law and apply the law and not have the luxury of liking or disliking it. With that said, I believe that Republican is how I run because, frankly, that's what I am. I don't know how else that would work. And I think it would be dishonest or disingenuous to do it any other way.
Okay. Dan, same question. What does it mean to you to run for this position as a Republican?
I am a Republican because those are the moral standards and constitutional standards to which I believe. I believe in life, liberty, public safety, and the protection of all our rights in the Constitution. While no judge would decide a case based on someone being in front of them being a Republican or a Democrat, I think people have a right to know what values you hold, and the way we've decided to do that in the political process is through the use of political parties. I'm proud to be a Republican. I was first elected to office in 1997 as a Republican. Those are the values I hold. I think those values represent this community, and I'm glad that people vote on their judges in Cole County and they're not appointed by somebody that is not accountable to the people.
Okay, thank you. Dan, this next question will start with you. Will you commit to monitoring sentencing data so racial inequities can be detected and remedied? And how would you propose we try to achieve that racial equality?
Well, I disagree with some of the suppositions in the question. I would certainly commit to tracking any sort of racial inequities, but the question seems to presuppose that somehow the system is responsible for the racial inequities. Clearly, there are problems in certain communities where they're disproportionately represented in our criminal justice system. But the solution is not a top-down solution from the court, it is a bottom-up solution from the communities. the number one factor as to whether you're going to get in trouble with the law is whether you come from a two-parent household or not. The second factor is whether you've graduated high school. So tracking people coming through the court system is going to do nothing to remedy those two situations other than maybe give someone else more data to make sure the people don't come into the system in the first place.
Okay, David, same question.
Well, certainly, any data that can be collected is helpful. So long as there's a perception that the system is broken, then the system cannot function at its finest. If people in the community of any color believe that they're not getting a fair shake in the court system, then we need to address that. If they are in fact getting a fair shake, then it's an education issue, educating them that, hey, the system is working for you and here's the way that you can deal with it. But so long as a segment of society feels that they are not getting a proper attention within the courthouse, that means the system cannot run at its most efficient. So how do we address that? Through education, through allowing those individuals to communicate with someone at the court, an ombudsman, some sort of a resource officer, to say, these are the concerns that I have with it. And then we look at those and we address them. Is it one individual just complaining because they committed a crime and got sentenced for it? Okay, we're going to analyze that. But do you find some systemic problem that's there? That data always helps you run the system better. And so gathering that data is beneficial at any level, if for no other reason than to address whether there is in fact a problem.
Okay, thank you. Let's see. So let's see, David, we'll start with you on this question. Actually, Dan. Nope. We started David.
I think it's Dave.
I think it is Dave.
I think it's Dave.
I'll take it. How's that?
I'm getting confused here. Okay, what is the one issue you think that has not been covered from a media standpoint regarding courts,
In this election in particular or generally?
generally?
I think there is a lack of understanding of the judicial system. The number of folks that I talk to on the street who want a baseline definition of the difference between a municipal judge and an associate circuit judge and a circuit court judge is really somewhat astounding. I think we hit the big things in high school civics classes, and unless you're majoring in some of these topics at a higher education, it's not there. Educating of voters is an absolutely crucial factor as we push to have more people engage in the voting process. That's great, but having them show up solely because they recognize a name, that's not really an efficient use of the process. So one of the things that I think can really be done by the press is some baseline education of what the system is and how it works. Some of that is incumbent upon me as a candidate and Judge Green as a candidate to educate those folks who come up and ask. And I'm betting that the folks who you talked to before from Division 5 and certainly the folks from Division 3 will do the same. We can benefit in that. But educating the public as to what they do and what sort of cases these individuals will be hearing becomes very important and, again, helps the system to run more smoothly.
Okay, thank you. Dan, same question.
We are very fortunate as Americans to be participants in the greatest legal and justice system that the world has ever known. It truly is the Cadillac of any other legal scheme. Now, that being said, Cadillacs may be more expensive to run, they may be more expensive to maintain, so because we have the best system, we have to put the resources behind it to make sure it's functioning at full throttle. And if that means paying, getting more lawyers to represent indigent defendants, then we need to do that. If that means having bigger courthouses so that people want to come and serve on our juries instead of being, crammed into a 120-year-old building, then maybe that needs to happen. I like our courthouse. It is a historic courthouse. I like it being downtown. but it needs to expand because the way the system works is our jury system and our trial system, and it's getting just quite a little bit cramped.
Okay. All right, gentlemen, so let's begin with our closing statements. We'll start with Dan.
I did some statistics in anticipation of this race. Last year, calendar year 2019, Division 2, of which I am in charge of, was assigned 3,200 cases. The other two circuit divisions had 2,100 cases assigned to them and 1,400 cases. Despite having, in one respect, twice as many cases, the National Center for State Courts gave me a 99.8% clearance rate on my cases. I think I'm doing a good job. I'm the only candidate with the real experience. I am a real conservative that reflects the values in this community, and I've chosen to raise my family and live in this community for that reason. I would appreciate your vote on August 4th in the Republican primary.
Okay, thank you. David?
Thank you, Mr. Castor, and I appreciate the opportunity again to be here. Again, I'll put my experience and my knowledge of the law up against anyone. My courtroom experience is every bit as valuable, and in fact, more valuable because I've seen what works with other judges, and frankly, I've seen what doesn't work. I work from 7 in the morning every day through the evening. I take work home and I work there. My work ethic is what will drive this job and what will make the courthouse better. Change for the sake of change is not a good idea, but change to make the system better is what keeps America going and what keeps the legal system prospering. I'd like the opportunity. I think that I am uniquely qualified for the opportunity, and I would appreciate your vote on August 4th, Dave Bandre. Thank you.
Gentlemen, thank you for coming tonight.
Thank you
And,
again, Mr. Castor. I really enjoyed it, and this is a great service you provide.
Thank you very much, and I would again encourage voters to get out and vote August 4th. We are going to take a brief break and begin again with Division 3. All right, so tonight we're going to start our third forum here. This will be Division III Circuit Judge. As mentioned in the previous forums, prior to tonight, the candidates were advised of the rules of the forum. They will be given 1 minute for an opening statement, and then I'll begin asking a series of questions. So let me introduce tonight's candidates. So to my right is Mark Richardson, former Jefferson City Municipal Judge and Cole County Prosecuting Attorney. To my left, Cotton Walker, former Jefferson City Municipal Judge and currently serving first term as Cole County Associate Circuit Judge. No Democratic candidates filed for the position, so the winner of the Republican primary is virtually assured of election in November. So we drew lots to begin, and Mark, you will begin with the opening statement.
Thank you, Mr. Castor, and thank you all for having this forum. I'm running for circuit judge because I want to make changes to our system. And part of those changes are certainly to protect the public, to speed up cases, and to deliver a justice that's far better than what's been delivered by my opponent up to now. There are too many people that have become accustomed, especially criminals, to the free bail, no jail type system. And those who know me know I am a true law and order conservative approach judge, and one of my main policies as judge is to make sure that justice is delivered in a prompt manner and that people who need their cases decided can get decisions from judges quickly. The experience I have in reviewing cases and as judge for 7.5 years, sitting on the municipal bench deciding cases where I earned a reputation as a law and order judge, and then 12 years as a prosecuting attorney where I tried the most significant jury trials, some of which have been tried in our county in 2 decades. I believe that I have what it takes to become a judge that will make changes that better serve our community. Thank you.
Okay. Cotton?
Thank you and good evening, and thank you, Gary and News Tribune. Appreciate everyone listening in online or on JCTV tonight. I am Cotton Walker. I'm currently serving as the Associate Circuit Judge, as Mr. Castor alluded to. I was elected that position in 2018, and before that I served as municipal judge elected and municipal judge appointed, and also served in this room right here as municipal prosecutor prior to that. I am married to my wife Deborah of 25 years. We have 2 children. You see us in the community. I'm involved in volunteer organizations and supporting the community, and as I have been throughout my entire career, from when I started practicing law and returned to Cole County in 1991. Thank you again for the opportunity.
Thank you. So with our first question, we'll start with Cotton. In this period of civil unrest that's sweeping much of the nation, what could you as a judge do to address the public's concerns about safety and equal justice?
Well, obviously, equal justice is a tenet of my practice on the bench, and as we've talked about on the campaign, when I've talked to citizens in the community, to the extent that we could do that in this COVID campaign of 2020, a judge has a responsibility to stay intentionally connected to the community and know what the expectations are and reflect them in the decisions on the bench. I do believe that we have, while we have a duty to reflect those community's concerns, including in the era of civil unrest in response to things that did not happen in Cole County, but at the same time, a judge has to remain impartial. I was asked to, for example, speak out or talk about the march here in town after Mr. Floyd was killed, and both during, before, and after, I had to remind people that as a judge where some case could come before me, I could not comment. I take that independence as a judge seriously, and while you have to lead in your involvement in the community and lead in your decisions on the bench, you can't take a position or speak out on certain individual cases as they may come before you.
Okay, thank you. Mark, same question. What could you as a judge do to address the public's concerns about safety and equal justice?
Well, as to safety, First and foremost, if people know that the court is predictable in terms of the punishment fits the crime, and if the police know that the leaders of a city back them up and allow them to do their jobs, then there will be safety and the riots will not have to be going on in the cities. Where generally Democrat leaders for too long, through their judging and prosecuting, etc., have wanted to be social justice workers, much like I believe my opponent is a social justice judge or social worker judge, then things deteriorate. If people know that there's rules that apply to everyone, and peaceful protest is not people blocking interstate highways or tearing down buildings or setting police stations on fire. Equal justice occurs also when judges, and I as a prosecutor and judge before, and as Mr. Walker said, he was a municipal prosecutor also, and he was a Democrat elected municipal prosecutor here. And I believe that there is a difference in the party affiliation that I subscribe to is law and order is what guarantees people's safety. And allowing the police to do their jobs makes people safe and also strives towards equal justice. And so when we get off on trying to keep people out of jail all the time, then we're headed down the wrong path in terms of keeping the public safe. Safety is people saying, I don't want to have to go see that judge, which when I was judge, many police officers and citizens will tell you that people told them they did not want to come to city court to see Judge Richardson. And that's a deterrent effect. Judging can be done in such a way where there's a deterrent effect and there is fairness and equal justice for all people. But it has to be by rules and law and order. Thank you.
Okay. So, Mark, let's talk about alternative courts. How would you assess the circuit's use of alternative courts? What areas are they excelling or could improve their impact? What areas do you believe they are falling short of the original goal or providing justice?
Our circuit courts, and I was involved in them as Cole County prosecutor for 12 years. We always had a representative in every one of the alternative court programs. Those programs work best for first-time offenders, non-violent, who have no prior records. Those programs fail when judges put people in those programs that have prior records, especially those records that contain violence in the past. And they also work good when they're attended to regularly, and violations, people who violate the requirements of the program are removed from the program early on so that those who are benefiting from it can benefit more as our society does. The worst that I saw was programs where people who shouldn't have been put in them were put in them. People with violent records got into programs. People sometimes that were dealing drugs and had never taken drugs got into programs. As time went on, more and more, the police information to our office and our information to the program that someone was selling, and therefore that's why they always tested positive, was disregarded. And so people were in the program that were a detriment to the program because they weren't removed. And as I said, the programs have a place, but it's very important that the person that's a gatekeeper, which is the judge and the screening, or ultimately the judge, ensures that the taxpayer dollars are being spent wisely on that program to get the best result, and people who shouldn't be in the program aren't put in it, and people that fail it quickly are removed so those that are benefiting can continue to benefit and be a good citizen after they're done.
Okay.
Could you repeat the question? I want to make sure I get all the answer.
Absolutely. Cotton, how would you assess the circuit's use of alternative courts? What areas are they excelling or could improve their impact? What areas are they failing or falling short of the original goal of providing justice?
Very well. Well, alternative courts, and in Cole County, to be clear, we have a veterans court, we have a adult drug court, we have a DWI court, and we have a mental health or co-occurring court. And statistically, courts who have high risk, high need people, these are mostly felony after conviction, if it's properly applied, and that's something that when I came on the bench and started being involved in our local court, if there was something that we didn't do a good job of prior to my taking the bench at the associate circuit level, was we didn't always have post-plea participants in the program. I do believe it needs to be post-plea. Prior to 2019, when I became involved in the local treatment courts, it wasn't always that way, but we have moved that way because I believe that's a best practice. But then statistically, treatment courts are the best way to reduce repeat offenders. The best way. Now, it's because they get the attention, because they get therapeutic responses where those are appropriate, or consequences where those are appropriate. Consequences sometimes for the judge, even in a treatment court, can be jail. It can be kicking back out of the program, in which case most of those cases are probationers, and they go back to the original judge where they already pled guilty, and then they are sentenced, usually to prison.
Okay. All right, next question's on gun violence. Cotton, gun violence is a concern for many in mid-Missouri. How do you approach cases involving the use of weapons in a crime? What role does a judge have in stemming gun violence in society?
Well, this is a good question, and it is a concern in our community. You asked a question earlier of candidates about what they may have heard from the public, and gun violence is one that I've heard. It also gives me an opportunity to talk about how I handle the bond rules, because my opponent shows a fundamental lack of understanding of what the bond rules are from the Supreme Court that changed since he left the prosecutor's office. If someone commits a crime and they come through my division in Associate Circuit Court, I am doing 98% of the initial bond hearings, as described by one of the candidates earlier. I believe Mr. Smith kind of went through the 48-hour hearing and then the 7-day hearing. We are factoring in certainly the risk to the community and their risk of failure to appear, but there are also 12 other factors in the rule that we have to factor in. However, you can ask any member of the local defense bar, if a weapon is involved in the commission of a felony and it's brandished or certainly fired, they don't get a bond. Now, the Constitution says all but capital cases are entitled to bond or bond consideration, but in the associate division, the one associate division we have right now, if a felony uses a gun, then they do not get a bond, because I believe they are a threat to the community automatically. And I believe that is something that's important for the community to hear, and for the defenses, and if you will, the defense bar, the defendants and the defense bar to know that, so that it can hopefully reduce the amount of gun crime.
Okay, thank you. Mark, same question.
Okay, Mark Richardson, yes. First, let me address the bond rules. Judge Walker let out a armed robber, first degree, on a free bail, free ROR bond, named Levontre Williams. The paper is aware of this. He later, Mr. Williams, got charged with acting with another to shoot a woman in the back within about 90 days or so of getting out on the free bail. That's what I am not for all the free bails on dangerous criminals. We have a place. We're a wealthy county, so to speak. We have a big jail. We can hold them, and the public deserves us to hold them. And the thing I get from the voters out there is they're tired of seeing people commit violent crimes that should have never been on the street because of their prior offenses. Now, as to gun violence, our statute began as an armed criminal action statute that said, in addition to any other punishment, an armed criminal shall get an additional 3 years. Now, that became interpreted by our courts to mean it could be concurrent. I believe those should be consecutive sentences. And if judges want to get serious about stopping gun violence, that's the way to do it. So that if the minimum is 10 years on an armed robbery, because it's armed, then tack on at least 3 years consecutive, which hurts a defendant more and sends a message also to the public that we are not going to tolerate gun violence, because we don't have to tolerate it, and judges can stand firm on that and make the punishment fit the crime. There's no reason with our wealth that we have to live in fear of criminals carrying around guns. And I think that it can easily be addressed so that we begin piecemeal to make sure that those who carry guns and commit crimes see a punishment that fits that crime because the inherent risk that them bringing a gun into the crime adds to a person getting killed. Thank you.
Cotton, would you like to rebut his statement?
Well, he's talking about an individual case that he doesn't know all the facts about. One of the factors that a judge has to also consider is in the 12 factors is the weight of the evidence of the case, because the Constitution says you are not guilty until proven otherwise, and you are entitled to bail. In the individual case, I don't remember the exact situation, but he certainly didn't have the information that the court did, nor that the prosecutor presented in that case.
Okay.
Can I rebut that? I have the information from the detective that worked the case who got talked to about it, because it was serious. When I'm sitting and I see that kind of crime occur, an innocent woman driving down the street is shot in the back by someone who should have been in jail on a serious armed robbery, first degree, is a serious offense. A minimum 10 years to 30 years or life imprisonment is what the person faces, plus whatever the armed criminal action would be on whatever weapon was threatened to be used. And so, yes, that person should not be on bail, and the public, I can tell you, is tired of seeing that going on in our community when it should not be going on.
Okay, let's go to our next question. Mark, we'll start with you. You've said crimes against law enforcement officers haven't been given the priority they should be. Can you give examples of where that's happened and what should have been done?
Well, sure, it's happened right here. When I was municipal judge, I had certain predictable sentences for serious offenses. So if a person is found guilty of assaulting a police officer, they have to serve time in jail. That occurred for almost 8 years while I was down here. That sometimes doesn't occur anymore. And if I've always said, if our police cannot protect themselves and be given a degree of protection from the courts, then how are they going to protect citizens? And they don't get paid enough to do their job, get assaulted, and have someone say, well, that's part of your job. It's not. They're human beings, they're citizens, and when someone assaults them because they wear the badge and they're trying to enforce the law, that person needs to go to jail. And when I don't see that happening in our courts, it makes me sad. It makes me know that more police are going to be leaving than staying. And we need the police and have to have the police to have law and order and safety of all of our citizens, especially the most vulnerable, elderly, and young.
So to follow up that question, though, you've couched us that that's existing today. So how prevalent is it that you've witnessed crimes against law enforcement?
Well, oftentimes resisting arrest has, to me, risen the last 6 years I was prosecutor versus the first 6 years. And assaults on officers rose. And it is encouraged sometimes by judges of municipal courts and associate courts who did not follow through and give the punishment that our community deserved to be given out for assaults on police officers. And I have heard many times, not only from police officers, but from citizens, how disappointing that is when it occurs. And if we want to keep police, they have to be able to protect themselves, and they have to know that when they get assaulted for no other reason than they're wearing a badge and a uniform and trying to enforce the law, that person's going to spend time in jail, not some suspended probation.
Okay. Cotton, do you believe crimes against law enforcement officers should be given a greater priority? Why or why not?
Well, yes, and in my work on the bench at the municipal level and the associate circuit court, when a defendant has a conviction for assault of a law enforcement officer, they get jail time. They got it, jail time, of course, municipal court, the limitation was 90 days. And in fact, while on the municipal bench, we gave that maximum sentence on multiple counts to a particular defendant. We do the same thing at the associate level when they are convicted. I support what they do. A lot of those assault of a law enforcement officer, just so that everyone understands the issue, is when somebody also flees or fails to obey or interferes with an arrest, which is a horrible thing. It puts, given especially what we see nationally in the tenor, the risk on the law enforcement officer, the risk on the individuals, and the risk of other bystanders, some of whom may be obviously very innocent or not involved. So Should it be given more attention or more priority? Absolutely, because it is a tenet of the justice system and how we do that in Cole County.
Okay. Next question will go to Cotton. As a judge, how can you remain impartial while accepting campaign donations from individuals and groups?
Well, everyone who knows me knows that I remain impartial in everything that I do on the bench. There are campaign finance laws that show who has contributed, but also judges cannot solicit funds. So I have not solicited a dollar in this run or last run directly from any individual, whether they were an attorney, potential litigant, or what have you. But then we also have conflict rules. And if someone who has been a family member or contributor or a close friend or close neighbor, number one, the judge has a duty to disclose the potential conflict, and number two, the judge has the duty to then step off the case, recuse him or herself. I do believe our political system is built on money. We have to pay for ads in the newspaper, for example. We have to pay for the yard signs, although I think this time, though they're great candidates with lots of fantastic signs, we may have been beat out by the roofing companies, and at least in the western part of Cole County during this time. But frankly, I don't keep track of who contributed to my campaign or maybe an opponent's campaign, and that also assists in making sure that I remain impartial in any decision I make on the bench.
Okay. Same question, Mark.
Thank you. As prosecutor and also in this judge race, I have not accepted money from attorneys. I've not ever solicited money from attorneys in those races. I will remain impartial no matter who gives me money, because the reason they're giving me money is, I believe sincerely, they want to see a change at our judge level that we're going into. This is Judge Joyce's position that she's leaving. Mr. Walker has another 2 years on his term, and I think people want to see a new judge up there like me, who is a law and order judge. They are giving me money because they want that change, not because they want partiality. And I think a judge can remain impartial. I will note, and he does say that the rules allow you to see that, he has gotten several donations from mainly Democrat lawyers in town. And can he remain partial? He says he can. I hope that he can in his current job, and if he wins this one also. But I do not accept that money just to avoid the thought that someone may have that because they hired this particular attorney and they saw that that attorney gave money to a judge, that they may get some better deal. And they don't. I believe they don't, but there shouldn't be that worry about it, and I don't want that to occur either when I was prosecutor or if I become judge. So there won't be that worry for me.
Okay. Next question, we'll start with Mark. You stated the court system must address issues with lengthy delays in civil and criminal cases. Explain how you've come to that conclusion and what you would do differently as a judge.
Well, part of it is, and I have looked at Judge Walker's dockets, and I see misdemeanor cases pending for more than a year. Now, society has an interest in getting those cases done, so the smallest cases in the system certainly need to be done within 90 days to 120 days. And the Supreme Court's issued guidelines on when cases should get done. Serious felony cases should get done. The society, the community has an interest in getting, for example, a murder case done in a timely way. The victims have an interest, and also the defendant, who has a speedy trial right, but many times doesn't file for a speedy trial. Still, there's an interest in getting it done. And the longer cases languish on the docket, then the more cases that pile up. The more people feel like they're going into lengthy dockets that never get done. They have to wait forever while they're there. Cases get continued, and it can be stopped. When I started as a lawyer in a serious felony case that had been set for trial within 9 months of the date of the crime, if someone came up with a continuance motion that was valid, the judge would generally do this. Okay, I feel like I've got to grant a continuance. How long is it going to take to get this done? Or you're going to get it done in 30 days because we're only continuing it 30 days or 60 days. It wasn't continued for another year out. Now, we're getting a fifth judge in our circuit, and these cases need to move, and I will do my part, if I'm elected judge, to ensure that people get a swifter, prompter decision than they're getting now.
Okay. Cotton, do you believe an issue exists with lengthy delays in civil and criminal cases? Why or why not?
Well, right now, the only reason that might be true is because of COVID. We were issued an order by the Supreme Court to prioritize only habeas corpus and felony criminal matters, but not have jury trials for a period of many weeks, a couple of months. And as that was happening, I was modifying the dockets so that once we came out of COVID, we could get every court case on a docket. We've added dockets. Tomorrow, we have 2 new dockets that we would not have had pre-COVID to make sure the cases move along. Cases do not delay in my court unless there is an issue of getting a public defender assigned. I heard one of the speakers earlier talk about that. That is an issue where there is jail as a possibility. Our Constitution says everyone has a right to counsel, and if the public defender says you qualify, right now, for a while there was a long wait list. They have found some funding, thanks in part to our work at the courthouse, and that wait list has come way down. But the cases are moving, and speedy trial requests are obviously kept up with it. On the civil matters in the Associate Circuit Court are obviously cases litigated over less than $25,000 in controversy, but also landlord-tenant and some other civil matters that are very important to the individuals. And when we hit the COVID reset, I continued those cases only a couple weeks at a time, just hoping and waiting for us to be able to take up those matters to protect each side of the litigation situation. You know, for federal housing, there was a national stay on evictions, but in Cole County, more of our landlords are individual property owners who may also rely on that rental income on their property. And you can see that we do move those along, and I make swift decisions after trial. Cases do not stay under advisement, as you might say, in my division, more than about a week.
Okay. Next question, we'll start with Cotton. Do you think judges should have more leeway in sentencings?
Well, you know, there are certain things, there are certain guidelines and certain mandatory sentencing statutes, and I do believe that the judge in the individual case has the most information to make the best decision on a sentencing. Obviously, in jury trials, sometimes the jury gets to make that sentencing. Do I think we need more leeway? I'm not sure that's the way I see it, but you do need to trust the discretion of the judge with the experience being in a courtroom, knowing each fact in that case. We have to hear from the prosecution and the defense on the sentencing as well, and we rely on other factors such as probation or sentence investigation. But I do not like legislating from the other branch of government to the judiciary to tell us a particular case has this exact sentence, because each case can be different. At the same time, when it's a harsher penalty for a harsher felony, I believe it's deserved, and that's how I will sentence when I sentence on felonies. Of course, right now I hear felony cases, but only to the preliminary hearing stage. And I also believe that while in the associate division and involvement in treatment court, we're talking about giving people a second chance if they're a first-time offender or something. Once you get to that felony level, once you've committed more than one felony, you should expect to go to prison if you come through my court.
Okay. Mark, same question.
Okay, thank you. Yes, Mark Richardson, and certainly judges need a great amount of leeway in sentencing, but that leeway is confined to a range set by the legislature, of course, through the people. And those are important ranges that judges have to look at, and they have to sentence according to that range. A component of a judge's sentencing is not so much in the whether they're within the range or not, because they have to for a lawful sentence, but the experience that judge has in approaching that case. I've tried over 120 jury trials. The circuit court is a jury trial court. When it comes to sentencing, my experience is going to best serve our community in who gets the upper end of that range and who gets the lower end of that range with imprisonment. Another important thing going into this would be, if I'm elected judge, is my understanding and knowing that a year ago, a component of our truth in sentencing law was removed by the legislature and signed by the governor that changed the 40, 60, and 80% rules when a person's eligible for parole. So as a judge, I now have to keep in mind that I'm not going to get a guarantee on a lot of cases that as prosecutor I was doing where we got a guarantee, but they were changed retroactively, so that some case where we told a victim, we know that because of the truth in sentencing rule, this person will not be eligible to have a parole review until they serve 50%, let's say, of a 4-year sentence. So they're going to be in for 2 years. With that removed, we can't say that. And without that certainty, it makes it a much tougher job to sentence defendants coming before the court in the future than it did in the past. And I think my experience, as I said, in circuit court, where jury trials are a big part of the system, then my experience will better serve the public to have me deciding where in that range a person's sentence should be.
Okay. All right, so let's start our closing statement. So, Mark, we'll start with you.
Okay, thank you very much, Mark Richardson, and thank you for hosting this. And I want to say to the people watching how humble I am in the fact that they gave me the chance to serve nearly an 8-year term as the municipal judge of Jefferson City, where I had what many people have described as a very well-respected court for the community, and how great that was, and the great run I had of being able to serve this community as the elected Cole County prosecutor for 12 years, where I worked hard every day trying to see that justice was done, and that as an advocate for our community, for safety. I understand going in this, and I want people to understand, as a judge, I'm no longer would be an advocate. I will be an umpire. I'll have to weigh out the evidence in cases and make decisions as a neutral and impartial judge, as I did before when I was in municipal court. And I would like to remind the people that need to recall this or check with police officers. The things that held true to me based on my values as a tried and true lifetime Republican will hold true for me as a circuit judge, and I would appreciate your vote August 4th to help me get back into the court system where I can serve the public. Thank you very much.
Thank you. Cotton?
Thank you, Gary, and thank you, News Tribune. I appreciate also the opportunity to be here. I see it as a part of my public service. I was initially appointed as a municipal judge in 1994, serving in our communities of Russellville and Lowman, and then substitute judge in this room, actually, as municipal judge, as well as an interim judge here twice before being elected here, and then serving in the associate circuit division at the courthouse. I am anxious for us to have a second associate circuit division, whether that's with me and one other judge or with two new judges serving in the Cole County Courthouse, because it is a busy circuit. But make no mistake, cases in my division get the right attention and they move along. So I gave my introduction by telling you about my family and what I've done in the community, but voters know me. You know me, and don't just judge me by what my opponent says I am, because you know me better. Believe in the me that believes in you, and I appreciate your vote. Thank you.
Thank you. Thank you both for being here tonight. And again, I would encourage voters to come out August 4th and help decide this election. On behalf of the News Tribune, I'd like to thank the candidates for all three of these races for participating. I'd also like to thank Jefferson City and JCTV staff for their assistance in holding and broadcasting these forums, with an acknowledgement that we've had some issues with the video feed. Our intent at the News Tribune is to post tomorrow the video feed for those who perhaps wanted a little bit more clarity as to who was speaking, as well as just a refresher of what was said. So that will be available at newstribune.com. So in addition to the stories, I'll do a little soapbox promo here for my company. In addition to our coverage of these forums tonight and tomorrow's News Tribune, we'll have a variety of means by which you can become more informed about these races. We will be asking candidates questions we didn't get to tonight, and lastly, we'll be publishing a voter's guide on Sunday, August 2nd. I would just close by saying our society is served best by an informed and active electorate. I would encourage you to take advantage of the resources and then get out to vote on August 4th. Thank you and good night.